Good morning. This is Ron Mickens. You know the topic. Fraud upon the court. You be the judge. Fraud upon the court makes void the orders and judgments of that court. Repeat that again. Fraud upon the court makes the orders and judgments of that court void. Void. Nullities. They are of no force or effect. Damron, Stewart Title, fraudulently, frivolously, faked a complaint. Copy of their complaint. It's frivolous. It was a preempted strike conspired by State Attorney Jerry Hill, along with Stewart Title and Stewart Title lawyers, to prevent us from being the plaintiff. They obstructed justice. We could have obtained a judgment from the beginning. Based on the pleadings, we could have obtained a summary judgment. Their true role in these litigations are defendants with no defense. Unequivocally, Judge Strickland and Judge Moore, findings of facts and conclusions of law on our fraud, cancellation of deed, quiet title, ejectment, breach of contract, claims and cause of action, proves it 100% that their complaint was fraudulent, frivolous, and fake. Make no mistake about it. Okay? So here we go. Judge Moore replaces Judge Strickland. Okay, she's going to fraudulently misrepresent that we, Ron and Gloria Mickens, desired and sought rescission. Both parties agreed on appeal that this was a fraudulent, a material misrepresentation. Okay? For a number of reasons. That her representation of fraudulent misrepresentation was factually and lawfully or legally incorrect. All right. Her next fraudulent act, she fraudulently, without jurisdiction, ordered we, Ron and Gloria Mickens, to pay Damron Construction Company for the purported reasonable cost of materials and labor. Damron Construction Company had been found guilty of fraud. Fraud had misrepresented the nature of a deed, fraud in inducement, fraud in the execution of the deed, fraud in the formation and the performance of the construction contract, fraudulently obtaining and maintaining a claim to fee simple title to our property. They had entered judgment against its complaint in its entirety. They were not entitled to any relief in equity or law. So we can see why this order is fraudulent. The next fraudulent order from Judge Moore, she orders us to permit discovery. This is a trick. We didn't invoke the jurisdiction for no discovery. We had a trial. Discovery comes before pretrial conferences and trial. We've already established the record. I think you can see why this is outside the scope of her jurisdiction. It's a trick because she's ordering us to consent. Court ordering us. That's dictating. That's slave master ordering. That's not consent. Consent, you got to have the option to volunteer or not volunteer. That's consent. You have to have the option to permit or not permit in order to have permission. This is a trick to trick us into giving our consent to set aside or vacate over 25 claims that we are entitled to as a matter of law in exchange for one claim where we have to pay the losing parties and their co-conspirators. So what? You gotta stay with me. You gotta stay with me. Judge Constein was their man to create all of these fraudulent judgments. Judge Constein started out fraudulently severing the case. That means separating the case as if they are distinct, independent cases. Judge Durrance and Judge Prince had consolidated the case because they were interrelated, intertwined, tied together. Damron, Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, and Harman-Highsmith, they conspired and made a fraudulent deed together. They conspired to fraudulently convey our property. They fraudulently converted our title. They fraudulently induced chase. They fraudulently slandered our title. They committed organized fraud, scheme to defraud, building houses under false pretenses. They were all in it together. They were co-conspirators. Their fraud was all interrelated. But hey, Judge Constein, watch this lie, watch this misrepresentation. He's going to separate or sever the case based on this fraudulent pretext or fraudulent misrepresentation that they were not interrelated, that they were not interconnected, that they were not integrated, that they were not intertwined. You see the lie? That they were not joined, that they were not inextricably tied together. Okay. You see the lie. Damron had been named in all three lawsuits, and fraud had been alleged in all three lawsuits. Their fraud was interconnected. The cases was predicated on the same operative facts. Now, Judge Constein going to order the clerk of court to maintain files, maintain the lawsuits in three separate files on one hand, and on the other hand, he's going to require us to have the pleadings to reflect that the cases have been consolidated. Okay, he's creating, he's fraudulently creating these parties as if they were independent, separate cases. So he's going to grant Elaine Damron Construction Company a sanctioned judgment for $234,854 against us. Talking about we failed to permit discovery. Now, let me share with you real quickly. Elaine Damron's them cross appeal on this very issue. And this is what they said. The court erred when it failed to award damages supported by the record and directed the parties to submit additional evidence. The prior appeal of this cause resulted in the reversal of the prior final judgment and remand to the trial court for entry of a new judgment, which is supported by the record. In other words, the Second District Court of Appeal reversed Judge Strickland's fraudulent own personal unique remedy, but they did not reverse Judge Strickland's findings on the merits of our 5 claims. Let me just make sure we're clear on that. They said the cause was not remanded for a new trial, nor was it remanded with instructions to take additional evidence. The remand was simply limited to entry of a judgment supported by the record. Neither Damron nor the Mickens asked for an opportunity to submit additional evidence on damages. By directing the submission of such evidence, the lower court erred by exceeding the scope of the remand. This court has clearly recognized that no principle of appellate jurisdiction is more firmly established than the one which provides that a trial court utterly lacks the power to deviate from the terms of an appellate mandate. In addition to being beyond the scope of this court's mandate, the evidentiary hearing ordered by the lower court was and is unnecessary with regards to the existing record. Now, this is the Damron / the Stewart Title them saying that this order to permit discovery is outside the scope of her authority. We've already had a trial, in other words. Okay? But Judge Goldstein gonna grant them a $234,854 judgment against us based on an accusation. Based on an accusation from somebody that we ain't even heard of. Okay? We ain't violated no order, but somebody made an accusation that we don't know and never heard of, and he claimed that caused Damron them not to inspect the property, when Damron them had already said that this was an illegal, fraudulent order. How you gonna give somebody a judgment who ain't got no claim, no equitable claim? No, a claim in law. Now, stay with me. They're gonna drop Damron from the lawsuit, dismiss him from the lawsuit. Alan Damron gonna pass a special warranty deed to Stewart Title Guaranty Company in exchange for Stewart Title dropping their fraudulent, frivolous, fake foreclosure against the Damrons and purportedly us. We weren't in no mortgage with anybody. They couldn't allege that we were in a mortgage and we had defaulted on a mortgage, but they had this fake foreclosure against their co-conspirators. They had to pay the mortgage off with insurance proceeds. They are not a bona fide purchaser. The mortgage was invalid. They paid it off a total failure. Okay, but they accepted a deed in exchange for the mortgage. But Judge Goldstein gonna enter a $202,615 judgment against Ron and Gloria Mickey, a foreclosure judgment in Stewart Title favor against us. Now, you gotta stay with me. This is unbelievable. Okay? Then he goes on with this, and he fraudulently create this frivolous trial order where he defamed us, where he stigmatized us, he mischaracterized, he misrepresented, and he fraudulently overturning Judge Strickland's and Judge Moore's findings of facts with all these lies and fraudulent misrepresentation, just defaming us, okay? And they reversing Strickland and Judge Moore findings, and the Damrons ain't even in the lawsuit. How you gonna reverse findings and the Damrons them ain't even a party to the lawsuit? This is just stigmatizing us to give first responders, the sheriff, the opportunity to lock us up or murder us. All of this fraud, okay? When the Second District Court of Appeal affirmed these fraudulent orders, that was their license to destroy us mentally, emotionally, physically, spiritually. The opposing parties, they saw this bias. The Second District Court of Appeal had violated their own order, awarding relief that was unsupported by the record, unsupported by the pleading, objected to by both parties. The very same order that they say that they could not have affirmed in the first appeal. But here now, they have allowed, they have gave these people the permission to treat us like slaves, deprive us of all of our constitutional and civil rights. And the lawyers saw this bias and prejudice, and they exploited it. They exploited it to the max. Okay? So this is why I know you can see these fraudulent orders, because we can see now through their illusions. This non sequitur. Oh, this is how they lied. These professional lies. That trial order This does not follow. Hey, wasn't no facts alleged. There was no trial. Okay? We were lynched. Stewart Title Guaranty Company did not have standing. They did not have a cause of action. They couldn't allege that we were in a mortgage with anybody. So they make up this fake trial order. How you going to give them a judgment based on something called a trial order instead of a complaint with a cause of action for foreclosure? I hope you can see it. I hope you can see it. Because under the federal law, which is applicable to all states, the U.S. Supreme Court stated that if a court without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. The sheriff enforcing all of these fraudulent orders and judgment. I hope you see what I mean now. Okay? So what we got to do? We got to subscribe. We got to share. In the words of Ida B. Wells, the way to correct wrongs is to shine the light of truth upon them. So stay with me. Stay with me. Because I'm coming back. I'm coming back. I promise you, I'm going to break it down. So I'll talk with you the next time.